Hi, I'm Brad Green, and I'm an attorney with King and Green with offices in Birmingham and in Blount County, Alabama. And so today I wanted to talk about a little bit of how custody laws in Alabama work. Now, child custody cases most frequently happen in divorce cases or in post divorce modifications. They also happen in the child support division of our juvenile court, where generally you have unmarried persons that have a child together and they could be arguing about child custody, visitation, and child support. There are other places where you might have a child custody case in our juvenile courts in dependency cases, for instance. But I'm not talking about dependency cases today. Those are things where there is abuse or neglect and there are not parents able or willing or fit to have custody of children, and other folks generally are involved in those cases. Today I want to talk about custody cases in Alabama involving the two parents of the child. Some of these cases, like I said, happen in divorce cases at the outset, and some happen in child support court, but it's the same basic law as it comes to child custody. In general, at the first instance of a custody case being filed in Alabama between parents, both parents are on the same footing, and the standard, if they can't make an agreement, the standard for the trial court is what is in the best interest of the child. If the trial court designates one parent as having physical custody or primary physical custody, and the majority of the time, and a significant majority of the time, a child is living with one parent versus the other, then if there is a subsequent custody case seeking modification of that physical custody, in Alabama, the parent seeking the change to get custody bears a higher burden. It's known as the McClendon burden or the McClendon standard. And just know that that requires more evidence to get custody than it would have required had you had a trial in the initial custody case. So a lot of times people come in, they want to change custody, and we have to talk to them about the McClendon standard. Now, other questions that we get a lot of times from people coming in is, what age does a child in Alabama get to determine who they live with? And the answer to that question is there is no law in Alabama that says that at a certain age a child gets to decide. That just doesn't happen. Now, in reality, the law says a judge, if they're trying the case, if a judge finds that a child is of sufficient age and maturity to testify and give their opinion about where they would like to live or with whom they would like to live, the court can consider that as evidence, but it's only a part of the consideration. Now, common sense will tell you the older a child gets, as long as that child doesn't have any other problems that take away from their maturity and ability to make good decisions, the older a child gets, the more important their opinion probably becomes to a trial judge. Now, there are lots of other factors that come into play in custody cases. Specifically in the law, there are provisions that talk about if a parent is found to have committed acts of domestic violence, that there are certain presumptions against them having physical custody of a child. Those presumptions can be overcome. It's generally always in the discretion of a trial judge to make these determinations based on the evidence. Just sometimes if there are certain things that have happened, there might be more evidence required than there otherwise would be to support a judge's decision. Also, we get questions about 50-50. In Alabama, there is such a thing as joint physical custody. There are certain judges in certain parts of the state that do enter joint physical custody orders more than other judges, perhaps. But that is just a decision that each individual judge makes based on the cases in front of them. No place are you going to find a judge that said, I always do 50-50. You won't find that. Each case is different, and there are facts. Sometimes you can have two really good parents in front of you, and the evidence about how good these parents are can kind of stack up pretty close. But then logistical problems might come in. Say if one parent works as a firefighter and works a 24-hour shift and then off 48 continuously, or one parent, their job takes them and they have to move outside of the school district where the child was going to school. Those are factors that can prevent an order of true joint physical custody being entered. Lastly, you hear a lot about standard visitation. There is no such thing as the standard in Alabama. It can vary from courthouse to courthouse or judge to judge. Some judges don't like to have a set standard visitation order. Some do. Now, there are things about most visitation orders that look the same. And that is how we divide holidays, how we handle things during the school year versus the summer. And there are very similar ways to give weekend visitation to people that you see those similarities across the board in judges' orders. But know this, there is no single standard visitation in Alabama, and there never has been. So it's important if you're in a custody case to know what to expect in the county or in the courtroom of the judge that you're assigned, what is normal in that judge's courtroom. An experienced attorney that practices in that area of the law and perhaps in that courthouse a good deal can probably give you that advice. Beware of what you find on social media or just doing random Google searches. It's important to try to find the best advice possible for something that's probably going to be one of the most important things that happens to you in your life. I hope these thoughts, however brief, were kind of helpful if you find yourself in a custody case. If you have any questions, please contact our firm or any attorney that you know or that you can get recommendations of, and ask these questions to an attorney who can give you answers more specific to your situation. Thank you.